See something else. Okay, there we go. We're on YouTube. Okay, welcome everybody to the morning session of the Kansas Court of Appeals that we've had to move to Zoom because of the horrendous weather out there. I hope everybody listening and watching is safe and secure wherever you are. I keep getting those loud emergency notifications that kind of shock me every time they come that say, stay off the streets. But anyway, welcome. I'm Karen Arnoldberger. I'm for another week. I'm Chief Judge of the Kansas Court of Appeals. And this is our January docket. Joining me today is Judge Stephen Hill, who, as of this week, is the longest serving judge in the state of Kansas. And also on our panel today is Judge Sarah Warner, who will take over as Chief Judge next week. So we are ready to hear your arguments. You'll have 15 minutes to argue. You both have appeared before us many times before, so you're well aware of the process here. We are very familiar with the facts of your case, so the more you can get into your legal argument quicker, I think the better it will be for you. And we may be interrupting you with questions. The appellant, you will be able to reserve any minutes you want. Do you?
Judge, I'd like to reserve 5 minutes, please.
5 minutes, okay. So anyway, if you just formally state your appearance, I'm calling case number 125355, State of Kansas versus Nicholas J. Kermer. You will see us looking back and forth all the time. We have several screens in front of us, as I'm sure you do too. So if we're looking away, it doesn't necessarily mean we're not paying attention. It's we're trying to follow along with whatever record or documents we have in front of us. So if the parties would state their appearance, please.
May it please the court, Nicholas Kermer appears by and through counsel Tricia Bath.
Thank you.
May it please the court, Your Honor, the state of Kansas appears by and through Deputy District Attorney Michael Serra.
Okay, with that, I'm going to go ahead and let you begin. Ms. Bath, you will have 5 minutes in rebuttal.
Thank you. Judge, I am always aware that the court is well versed in the facts, but I do want to make very clear, because this was really sort of our defense in the case, was that this was consensual activity between these two persons. And important to that consensual activity was all of the things that our client maintained happened, that he approached her in the chair, that there was reciprocal touching. She was fully clothed in this recliner, and eventually they wound up on the floor. He indicated that he had oral contact with her breasts. I believe he called making out with her boobs. He also indicated a recollection of performing oral sex on her. So there was oral contact between his mouth and her genitalia. He did not have a specific memory of any intercourse, but had some memory that she had grabbed his penis, which was not erect at the time, and either put it inside of her vagina or tried to put it inside of her vagina. She was completely nude on the bottom when she woke up and was wearing skinny jeans, socks, t-shirt, bra, and had made this move from the recliner to the floor. The alleged victim maintained that she fell asleep, not passed out from alcohol, which was also important in our case, fell asleep in the chair, and when she awoke, our client was having penetrative vaginal sex with her, and she had no recollection of any of those other things occurring. Part of our defense course was it was not credible that this movement from the recliner to the floor with all this other touching and the removal of clothes had happened, and that the alleged victim had remained asleep for all of this. And so that Mr. Kermer's version of events, which he told to the police in the lengthy interview upon arrest, was the more credible version. And that's why this issue of the amylase testing was very important to the defense. I'll go first, though, to our first issue, the El Nicky issue. I won't spend a lot of time on that because I think it's a pretty clear factual issue. And that is, in this case, both the alleged victim and her, at the time, boyfriend, now at the time of trial, he was her fiance and now he's her husband. They both said to the detective that they loved Nicholas Kermer. They had no reason to doubt Nicholas Kermer. They thought he was a great guy, these sorts of things. When the boyfriend, fiance testified at trial, Mr. Malik is his name, he, at the very end of his testimony, was asked, well, when you were talking to the detective, you said these things like that you thought Nick was a great guy and you believed him and you couldn't believe that Nick would do this. And Mr. Malik agreed that that's what he had said. And the last question the prosecutor, Miss Lee, had for him was, but essentially now, having had all this time to reflect on this, how do you feel about that? Or some words to that effect. And his response was, I never doubted Amber. She just couldn't have reacted like that, essentially, if this wasn't true. We objected at trial, alleged that there was an El Nicky violation. The court did find an El Nicky violation and instructed the jury ultimately to disregard that information. However, the court did not find or found specifically in the negative, disagreed that the prosecution had intentionally elicited that El Nicky violation. And as we made the point in the district court, this prosecutor had every question in a notebook and was turning the pages with the notebook. And the very last question, or set of questions, as I've relayed there, was essentially they knew that they were going to be playing this video with the detective of the two witnesses saying, we believe Nick's a great guy, Nick wouldn't lie about this, all this sort of credibility boosting. And then they had to have an answer for that.
Counsel, may I interrupt you, please?
Yes.
I'm sitting here trying to think of the significance of this, if in light of the court's instruction to the jury to disregard it. Doesn't that inoculate it if there is harm? The jury was clearly told not to consider this.
Our position, though, Judge, was that if it was intentionally elicited, that was misconduct, which should have caused a new trial, or granting of our mistrial motion. And that's the point I was making, is that the way this questioning came out in that sequence of the prosecutor knowing that this sort of bad evidence boosting the defendant's credibility was out there, before they called the detective, they put on the guy who says, I believed Nick would not do this. And then they say, well, but now that you've had time to think about it, what do you say? Of course, they anticipated he was going to say, well, now I do believe Nick did this, or now I do believe Amber.
And
they thought he was
the
going to
cure
say
for
my
this
answers.
would have been a mistrial?
That's what we're asking, would have asked for a mistrial. We're saying that the judge erred in finding that wasn't intentional.
And did you ask for a mistrial?
We did.
And what was the judge's response?
She found there was an El Nicky violation. She instructed the jury to disregard the evidence, but she found that the prosecutor did not intentionally elicit the El Nicky violation, and therefore there's no need for a mistrial. We disagreed with that.
Are you asking us then to weigh evidence?
No. I'm asking the court to review the record and find that this court, the trial court, abused its discretion in refusing to grant our motion for mistrial as to the El Nicky violation, because I think it was very clear from the record that that was intentionally elicited. There's no logical other answer that the prosecutor expected than the one she got, or words along that effect.
Counsel, to succeed with regard to this issue on appeal, you have to show prejudice. And I'm just having a difficult time finding that in light of the verdict here.
And I think that's where we would go with this and with my next issue. And I'm going to eat into my rebuttal time, obviously, on this now. And that's fine. I'll just keep going, Judge. And if I end up with not much rebuttal, that's fine. But as to both of these issues, the verdict should not drive whether or not there was bad conduct at the trial. I mean, essentially, we're being punished for doing a good job and him prevailing on the rape counts, when the conduct by the government, both as to intentionally eliciting El Nicky material, and then on the bigger issue, which is putting on evidence that was never disclosed to us from an expert, as well as putting on false evidence from that expert, never correcting it. All of those things, essentially, we got the verdict despite that. And of course, we all know juries often reach compromise verdicts. We don't know. We can't all sit here and play Monday morning quarterback that they didn't say, okay, well, we're going to acquit him of the rape, but we're going to find these aggravated sexual battery charges to be valid charges.
So in your mind, then, should there be an exception for a mistrial finding that we would not have to find prejudice? Because that's the standard that we apply on appeal. It's not that anytime there's an error, there's an automatic mistrial. We have to show that there's been some kind of an effect that has tainted the trial.
Right. And we believe that the resulting conviction, the aggravated sexual battery conviction, was the prejudice that the defense lost credibility early in the case because of the conduct of the prosecutor in presenting this DNA evidence in particular. And I'll move on to that from the Alnicki violation, if I may. The prosecution knew years in advance that we were saying they could test for saliva. They could test for saliva, and that would tell us whether his version of nuzzling and sucking her breasts and performing oral sex on her was more likely than her version. This was a true he said, she said case. And it wasn't where there was denial of the contact. It was just the context of the contact. And Nicholas's version would have been supported had there been saliva found on these parts of her body. There was DNA. There was seminal fluid in her underwear, but it was not DNA linked to Nicholas Kermer. And in fact, there were 3 other males found in their DNA found in the crotch of her underwear. So what we were saying and what our expert reports to the government said is, why don't you do some amylase testing on this? And so the prosecution at that time was Dan Dunbar. They were aware that was going to be our defense. And the state acknowledges even in their brief that the failure to test for amylase featured heavily in our defense. But the way that it featured is, and even as early as voir dire and opening statement, we were saying the state could have done this testing and they didn't. And then, without disclosing that this expert would testify to this on direct, which she did, the state put on evidence from Samantha Buck that said, I couldn't do the testing because I would have consumed the sample. That was factually untrue and scientifically untrue, and there's evidence in the record to support that. She also said that that is an unreliable test, and that word is important because it is a term of art in the scientific community. The state's brief repeatedly uses the word usefulness of the amylase testing. And that is not our complaint. She didn't say, I don't find it useful because it's a color change test and I don't have great eyes or it's hard for me to discern color. That was not her testimony. Her testimony was that test is an unreliable test. She repeatedly said it's unreliable, it's not super reliable, it's not really reliable. She said it on direct, she repeated it on cross, she repeated it on redirect. She said those things, and in the scientific community, reliability of a test means essentially it's not valid, we don't use it. The KBI does reliability testing. The KBI does not use tests that are not scientifically reliable, and they do use this test. So her testimony was scientifically false as to the reliability, and then, as I said, factually and scientifically false as to consumption. There was enough factually that it would not have been consumed, and scientifically, there you can do the test for amylase and DNA on the same piece of material. It does not ruin it for further testing as between those 2 tests. So she gave that testimony, which was not disclosed in a report, though they knew that we would rely heavily on that in our defense. And more importantly, and this is what makes it different from the Genzel case, with which I know you're familiar, Judge, it was not true. That the testimony was not only a discovery violation, but the testimony she gave was false testimony, and the prosecutor never did anything to correct it. The court didn't do anything to correct it. The court offered for the parties to reach some sort of stipulation, and the state would not agree to the same language that we would agree to, so we could not have an agreed stipulation. The court did not instruct the jury as to that information. The court did not strike any of that testimony, and the court denied our motion for mistrial as to that testimony. So there was no remedy for what the state later admitted was false information. During the hearing on the motion for mistrial, Mr. Henderson said, I knew what she said was not true the moment she said it, and I tried to fix it. And the way he tried to fix it was going through it a little more on direct or going through it on redirect. What he didn't do was notify the court or notify the defense that his witness had just given false testimony, even though he admitted that he knew that it was not true testimony. So the defense, in the crucible of trying to get the rest of your trial together, had to order
difference
transcripts.
between false testimony and incorrect testimony. Like if someone just gives testimony that is just wrong, but versus someone intentionally gives false testimony. Is there a difference?
I do believe there is a difference. I don't believe what she did in this case is the former, that it was inaccurate testimony, or the latter, whichever order you had them in. I know that's what Judge Parrish believed, that it was, I think she said, totally inaccurate testimony. This is a scientist. She comes to that courtroom cloaked with the aura of science. She also works for law enforcement. She's trained. She knows what it means for a test to be reliable or unreliable. Again, she could have used different words and said, oh, that's not my favorite test, or it's not useful. Those aren't the words she chose. And then with regard to the consumption issue, again, that was false on two fronts, the science of it and the actually how much evidence there was to be tested part of it. It was at the very least that part of it recklessly about her knowledge of the truth. Other scientists in her same organization testified that that was inaccurate. So I think in her case, she has a duty to sort of know what she's talking about when she comes in there as an expert for the Kansas Bureau of Investigations. I can't hear you, Judge Arnoldberger.
Your microphone's muted.
I can give you about 2 minutes of rebuttal if you want to stop now, or
I'll
if you
stop now,
want to-
Judge. Thank you.
Okay, all right.
Thank you.
Mr. Sarah?
Thank you, Your Honor. May it please the court. I guess I'll start with the last subject, Your Honors, with the unreliability of the test. First of all, we keep characterizing this test as a test for saliva. It is not a test for saliva. It is a test for a protein found in saliva, as well as about half a dozen other bodily fluids. It is a presumptive test, a color change test that Ms. White testified at the motion for new trial is highly subjective, and also more importantly, doesn't react the same way to every individual depending on the level of amylase in their saliva or other bodily fluids. As far as Ms. Buck's testimony goes,
Counsel, it's a common test though, right? This is a test that is used often by the state in these types of situations.
Your Honor, I can't say how commonly it is used. My knowledge of this test comes from the testimony below and the expert witness reports. It is a test used nationwide from Ms. Buck and Ms. White and T.L. Price's testimony. It is a test that is not used very often by the KBI. I disagree with the defendant's characterization that Ms. Buck gave knowingly false testimony or even necessarily inaccurate testimony. In context, she offered an opinion that the test was not super reliable. That's the word she used. In context, she was talking about the precision of the test as opposed to DNA, which is far more precise and preferred by the KBI. I don't believe she gave false testimony, and neither did Judge Parrish. I know Judge Parrish initially reacted that it was totally inaccurate, but then in her MDO, which she issued on the motion for new trial, she backed off of that quite a bit, saying various opinions disagree on this. T.L. Price, who's the director of the KBI, testified at that hearing that reliability is a term of art in the scientific community, and his belief was reliability means a test that can be performed repeatedly under the same set of circumstances to yield the same result. According to Ms. White, this test is not one of those tests. It's, subject to interpretation and also biology. So I disagree, and I do not believe that Ms. Buck offered false testimony. I also don't believe that it had any effect on the jury. The defense made significant hay of her testimony before the jury to undermine her credibility. I also don't believe, and I agree with the district court, that amylase testing would have done anything to assist the defense in corroboration. The defendant admitted that he performed oral sex on the victim on both her genitalia and her breasts. His DNA was most certainly found in her breast, and it was indicated in her underwear. As Judge Parrish found, that would, it may have corroborated his testimony, but it was already corroborated by his own statement. So again, I'm not seeing how any of this affected the defendant's ability to present a defense. I don't think it undermined anything based on the verdict in particular about the credibility of the defendant's defense and attack on the state, going that this was a sloppy investigation. It was poorly handled by the KBI, and there was a rush to judgment. That was their defense from the get-go. And I think that Ms. Buck's testimony was used very much to try and bolster that defense, and somewhat successfully based on the verdict. As to the discovery violation, Your Honor, I don't recall that Mr. Henderson said that I knew it was wrong when she said it. I believe what he said was, I believe she said it was unreliable, not scientifically unreliable. And it doesn't seem to be any question that he didn't know that she was going to offer that opinion. But as Judge Parrish found, her opinion as to tests she didn't perform is not a discovery violation. There are several other tests she could have performed, and her opinions on those weren't questioned. And is that discoverable about her opinions on the efficacy of tests that she didn't perform? My view of the statute is it doesn't extend that far. Otherwise, we would be really reaching into the minds of every scientist and every witness who we call to say, but what about these things that you didn't do? And what is your opinion on that? So I'm not going to belabor the point, Your Honors, because I filed a pretty substantial brief on this, laying out my opinions and the state's position on this. As to the Elnicki violation, Your Honor, I'll just briefly touch on that. As Judge Parrish found, the question was very open-ended. The response was unresponsive. The court properly found that the response, not the question, the response was an Elnicki violation, and promptly instructed the jury to disregard it. There's no evidence that the jury disregarded the court's instructions, and we presume they do what the court tells them to do. And again,
Counsel, help me understand this a little bit. The question was, or the previous statements in the interview were that we trust this person. We don't think that this could have happened, or we don't think he could have done this. And then the question at trial was, well, what do you think now? How could that be anything other than trying to get into the credibility of the witnesses and bolster one versus another?
well, I understand what the prosecutor was trying to do in this. They were trying to blunt the sword because that statement was there. It's like, this kid is like a brother to me. They were childhood friends. I cannot believe something like this would happen. I think the question was, how do you feel about making that statement today, was more reflective on his state of mind, not whether he believed anything. I don't think there was any way for the prosecutor to have known he's going to go into, well, now I believe everything she said. That was the unresponsive answer, and Judge Parrish acted appropriately after the objection, saying, no, you don't get to do that. Jury, you will disregard. You are the only persons here who get to assess credibility, and moved on from there. It was very brief. The defense promptly objected, but didn't get much further than that. So again, I have a hard time. I don't believe there was any intent to solicit an Elnicki violation. I also don't believe that just because the prosecutor had a notebook full of, I mean, I keep a notebook when I do direct as well, but it has points I want to make, not specific questions I'm going to ask. So I have a hard, I'm not seeing the connection there that the notes indicate that this was an intentional attempt to bolster credibility.
Well, but I'm curious then as to why you say she had to blunt the sword. I
Well,
mean,
it's not.
that
Honestly,
sounds fairly intentional. She had to step in and do something to dispute, to soften the effect of that pretty damaging for the prosecution testimony. Or
I understand that, Your Honor. I also I'm still kind of curious why this wasn't redacted, because going into his beliefs about things, maybe that was not something that the court should have allowed to get into at all, whether it was his belief on the defendant or the belief on the
that doesn't
victim.
matter. I mean, it was nobody
I
had
know.
a problem with it being in.
No, I agree there. At the same time, I think that the victim, excuse me, Mr. Malik's state of mind was something they had to ask. It was like, you said you have a hard time believing this. How do you feel about that today? You know, what was your state of mind at that point?
What's your response to Ms. Bass's comment that if we do find that the evidence supports that this was intentional, then a mistrial was required?
I still think that prejudice is required to be shown, Your Honor. I think that, again, as I put in my brief, I don't think the defense can show prejudice, and it is their burden. And the fact that the defendant, excuse me, Mr. Malik, was there testifying, he was the boyfriend, he's now the husband. I don't think there was any question in the jury's mind who he believed. So I don't think that the requisite prejudice is there. I think that the jury was ordered to disregard it. The jury is presumed to follow what the court tells them to do, and I don't think there's anything to indicate the jury did not follow that instruction.
Thank you.
The thing that I am having trouble with is not so much the credibility determination on the backside, it's the question itself. So the question itself is, in light of this, previous statement that we didn't, we can't believe that this guy would have done this. I mean, now what do you think? In other words, we want you to comment on your belief as to this person's guilt. Isn't that a problem?
Would be if you were asked, what do you think about that, about somebody's guilt, but it wasn't asked that way. It's basically, it was, have you reflected on that? What is your state of, what was your state of mind then? What is your state of mind now about having made that statement? And then he went into, well, I completely
That
believe
statement that we don't think that he did it. We can't believe that he would have done it.
He never said, I don't believe he did it, Your Honor. My recollection is he said, I have a hard time. Yeah, I had a hard time to believe this had happened. So, and again, based on their relationship, I can understand how he would feel that way. And I think it was appropriate for the prosecutor to ask him, it's like, what was your state of mind at that time when you made that statement?
But that's not the question I'm talking about. I'm talking about what do you think about that now?
Well, I think that is a fair question about what do you think about that now? What was your state of mind then as opposed to now? Why'd you say that? Unless the court has any additional questions, Your Honors, like I said, I filed a pretty substantial brief on this, and I'd stand on the rest of it unless the court has additional questions.
Thank you. Ms. Bath, you have any other questions from the panel?
No panel, no
Ms.
questions.
Bath, you have a couple minutes, and I'd like you to address this issue of what support do you have for the proposition that if this was intentional, a mistrial is required, regardless of the judge's admonition to the jury.
Thank you, Judge. I'm trying to find a place in my brief where I've cite those, so I don't have the cases from memory here, but important to this analysis, Judge, and again, I think it goes to both mistrial requests or our client, this court, I understand, doesn't sit and try to put themselves back into the shoes of the court, the trial court, but where this was intentional, if the court had made that finding, or in the case of the motion for mistrial with regard to the 223212 violation, we would not be sitting here talking about what the prejudice was because the trial would stop and we wouldn't have a great result, frankly, by the defense. So again, it seems as if there's a little bit of a, not by this court, but by the standard, a little bit of a punishment for getting a good result. That said, I just don't think there's a way for us to know what the level of actual prejudice was to him. The evidence that supported the aggravated sexual battery was, he said in his statement that he had gone over to the chair where she was and sort of touched along her hip to see if she was awake and, what responsive, and she began to touch him back. That was the extent that could have supported that verdict, absent the jury believing some of the rest of that. So this
let me stop you for a minute and go back to my question was, what supports your position that it's irrelevant whether the judge gave a curative instruction if it is clear that the prosecutor's Elnicki violation was purposeful? What then requires a what is it you're quoting?
What is our prejudice?
No, not what is your prejudice. I think you were saying, and maybe I'm wrong, I think you were saying that if the evidence supports a finding that this was a purposeful violation of Elnicki, we don't go to prejudice. I think that's what you said. We don't get to prejudice because if it was an intentional violation, it's an automatic mistrial. Am I misstating what I thought I heard you say?
I think if the court had ruled properly in the context of the mistrial and she erred, she abused her discretion in not granting the mistrial because she found that the elicitation was not intentional, is what I was getting at. So the court used her discretion. Her ruling on the mistrial was unreasonable.
Okay.
Part
All
of the
right.
mistrial statute, because she found inaccurately that this was not intentionally elicited. This is what I was saying.
Okay. All right. I misunderstood your argument.
Right.
Okay.
And
Thank
so then I was answering your question before as to what our prejudice was factually. And our
Right.
prejudice was that this was a he said, she said. It was a close call. It's more egregious than other cases where there have been even a close call, because on the 2212 stuff, what was violation was also an untruth to the court. But as to the issue of the Alnicki violation, and I know I'm running out of time, I'll wrap up. I understand that, and we cited Wilson in our brief that said there has to be a high degree of prejudice to the defendant. Our position on the prejudice is that all of these things essentially went to our client's credibility, which was the most important issue in the case. And when the jury came back with an aggravated sexual battery conviction based on, I went over and sort of touched along her side and her thigh, we believe, and we see juries all the time, again, come back with these compromise verdicts. We believe that our client's credibility, our credibility from opening statement, was affected by both of these errors. And in both instances, a mistrial should have been granted.
Thank you. Any other questions from the panel?
No questions.
Okay. Thank you very much, counsel. We appreciate your argument today. It was very helpful in ferreting out the issues. And we will take the matter under advisement and get an opinion out to you as soon as possible.
Thank you.
Thank you. Stay safe.
Thanks.
Good morning, everybody. We are still recording. We are still live. We did not pause for this at all. I will, and I'm assuming you were all online to hear the initial information I provided, who's on the panel, and that we are familiar with the facts in your case. So I will call case 127827 EF and VF versus Kansas Department of Children and Families. And if the parties would state their appearances, please.
Your Honors, may it please the court, Winnesell Baker appearing on behalf of the appellants denominated as EF and VF.
Okay, thank you. And did you wish rebuttal time, Mr. Baker?
2 minutes, Judge.
Okay. And for the Department of Children and Families?
Good morning, Your Honors. May it please the court, Mark Alton Burnt on behalf of the Kansas Department for Children and Families.
Okay. Well, with that, Mr. Baker, if you want to go ahead and dive in.
Thank you, Judge. Thank you for the opportunity to do this by Zoom. It's 1 degree at my house, and so
That's
thank
a
you.
heat wave. That's a heat wave.
Well, there you go. It may be colder where you fellas are, but so you've read the facts, the background. This is an administrative appeal to a district court. The administrative decision was rendered October 2nd, 2023. In the meantime, the court got hacked about midway through that and issued emergency orders October 15th, October 16th, halfway through that. I filed on October 28th a petition with the district court, which was confirmed. And the clerk notified me after the 30-day period that she was going to reject that. So I think the two things that the court has to consider today is A, is an immediate payment of a filing fee jurisdictional? That's the one thing. The filing was not untimely. KSA 6205 says that a paper is filed by delivering it.
Counsel, can I stop you for just a second? How long have you been practicing law?
Boy, now that's a trick question, Judge.
Uh-huh.
Well, long enough to know what?
All right. Now, do you remember in the days when you would file something, you'd go to court, you'd hand in your paper, and the clerk would have a file stamp and hand stamp it, and you'd hand your check over and your case would be filed. Do you remember all that?
I remember that you could actually file it and never get it rejected, as happens today. So
And
you
then-
could just, so we don't have, back then, you could just say here, and it got filed. Now you get
What?
rejection notices like what?
Well,
So
now
anyway, it's different.
my question is purposeful. And you'd hand them the check and they'd deposit the check. And if the check didn't clear, they'd come back and you'd get notice that you got to come in and pay your $35 or $50 or whatever it was.
Well,
Now, let me ask you this. Was that document still filed? Or was it not filed until the check finally clears?
no, it was filed.
Now, what's the difference now? Because the payment system is so much quicker. Is it filed when it's filed with the court, or is it filed when payment is received? Is that what the import of what this court is saying? The district court's ruling is?
Well, the district court, yeah, well, here's what the district court ruled. He ruled that it wasn't filed until you got the fee.
That's right.
Right. That's what he ruled. And then the second part of that is, even though the emergency order said you have discretion to deem an untimely filing timely, he said, I don't have discretion because you didn't pay the filing fee. So he wouldn't even reach that issue. So there are the two issues. So I think you're making my point, which is, which you scared me at first, Judge, but so I apologize. But it was filed. And in fact, my experience, sometimes you actually get away with filing something without paying at the desk. You leave and then you get a call from the clerk and said, oh, by the way, Mr. Baker, you didn't pay. Okay, let me fix that. I'll send you a check. So in this case, we filed it. The back and forth I had with the clerk. I mailed the check back in. She mailed it back and said, well, you didn't file a filing fee, a cover sheet. I said, okay. So I put the cover sheet in, send the same check back in. The filing fee was paid.
Let me ask you about that. Is there a local court rule that says there has to be a cover sheet, a cover letter? Or is that by state statute?
I
don't know of any statute that requires it, but I thought maybe you do.
I don't think it's required, Judge.
So it's a local court rule.
I probably, I'm sorry.
So then the clerk rejects it. What authority did the clerk have to reject it?
I don't know of any authority this clerk has to act as the gatekeeper that it did. And I briefed that in the filings, which is the judge decides all that. The clerk is just ministerial. You take it, and if it's going to get rejected, that's a judge ruling, not the clerk. The clerk doesn't act as the gatekeeper, which is why we fuss with all of this. And again, my experience has been in various courts. They'll say you didn't pay the fee. Okay, let me send you a check. And so you get it and it's fixed, no problem. But that's not what this clerk did. And so in the end, you have a timely fax filing. The paper was delivered. So it was timely. you got the payment. It's not like we sat on it. It's not, and then you've got this catastrophic issue where everybody's scrambling. I don't know what's going to happen between October 15th and my due date. Nobody does, but okay, fine. I fax it. And then I got the results.
Counsel, what about the fact that this administrative order that was the second administrative order says that everyone's allowed to fax file unless there's a fee that's going to be assessed. In other words, the fax filing itself wasn't allowed.
Well, Judge Warner, with that, I argue a separation of powers. The statute governs. You can't have a Supreme Court rule that overrules statute. 6205 says a paper is filed when it's delivered. There's no mention in 6205 or 6203 there has to be a filing fee. And in fact, the federal courts all agree with that proposition that it's not jurisdictional. I, in fact, cite to you two cases, the Anatech and the Avco case, in which in Avco, KSA 62001A, no case shall be filed or docketed, whether original or appealed, without payment of the docket fee. That statute said that, and Avco said, you didn't pay the docket, but we're going to let you go ahead and file it anyway. Anatech followed that and specifically said that the payment of the filing fee is not jurisdictional. So however you want to harmonize that or look at that, I think the bottom line is the statute prevails. I did pay the docket fee. It wasn't immediately paid, but it was paid. So no one's prejudiced here. And substantial justice, I mean, this is an unusual, hopefully this doesn't happen again, but it did happen. And I got caught in the middle of it and did my best. I know counsel says we should have driven to Topeka and done all that, but I wasn't notified until after the 30 days that the clerk was going to reject it. So it wouldn't have done anything. So I think it's a fairly straightforward case. I think that you reverse this and allow the filing, rule that the filing was timely, and let the court hear the merits of this case. So with that, unless you have further questions.
Counsel, one quick question, and this is a factual question, but when you fax filed the petition, did you include, like, before the security incident, if someone were to fax file and it required a payment, you had to include like a second page that had a credit card number on it? Did you include that, or because, okay. All right.
No, I didn't, because the order said we're not taking credit card payments. So, I mean, the game was blocked all the way around. So no.
Okay, thank you.
With that, unless there are other questions, I'll reserve my rebuttal.
Thank you. Mr. Alton Burnt.
Thank you, Judge. And again, may it please the court, Mark Alton Burnt on behalf of DCF. Your Honors, counsel and I agree in one respect that this is pretty simple. Counsel keeps indicating that the statute prevails, indicates that the administrative order needs to follow statute. The statute counsel keeps citing to KSA 60-205 is not at issue here. It's not the applicable statute. In fact, the statute begins by stating that it applies to any paper filed after the initial petition. This is the initial petition. So this falls under 60-203 and necessarily requires 60-2001, which requires a fee. Counsel indicated that in response to Judge Warner's question about attaching the credit card information, counsel indicated he didn't do that because he read the order that said they weren't accepting credit card statements. That same order indicated that he was not allowed to fax file because this document required payment. So what's happening here are the appellants kind of cherry picking what parts they want to use, when the reality is the entire statutory scheme and the administrative orders that were created by the Kansas Supreme Court need to be followed.
The district court's order is interesting to me, counsel. Is it clearly the import of that order that it is jurisdictional? And in other words, unless you pay that fee, the court will have no jurisdiction over this petition. Is that your basic understanding of the order? And do you agree with that?
Well, Judge, I'm not going to get caught up in language such as jurisdictional. I do agree that the court indicated that.
Well, why not? I mean, we have to grope with that issue. The court clearly sees doesn't have jurisdiction. So, do you agree with that? And if so, explain to me why.
Well, I do agree with that, Judge, and quite frankly, the reason why is primarily found in Supreme Court Rule 119. We keep getting caught up in. Counsel keeps trying to bring up this emergency and how nobody knew what was happening. But the reality is Supreme Court Rule 122, which deals with e-filing, says what to do in the event the system is unavailable. More importantly, Supreme Court 119 deals specifically with fax filing. And Supreme
I'm not
Court
talking about any of that. I'm talking about something much more fundamental. That is, the clear import of that order is, unless you hit the head pin and pay your money, the court has no authority to act on that petition. If that's so, how do you reconcile that with AFCO?
Well, Judge, how I reconcile with AFCO is in two ways, and I put these arguments in my brief. The first way I reconcile with AFCO is not the same statute that we're dealing with. AFCO specifically was appealed under 60-2101, I want to say, if I can pull out my AFCO facts here, which is not, first of all, that the statute doesn't exist anymore. Second of all, AFCO deals with an appeal from a magistrate court where the appeal is initially filed with the magistrate court. So the rules concerning magistrate court apply. This is not an appeal from a magistrate court. This appeal needed to be filed, needed to be initiated with the district court. Therefore, we have to follow the rules that pertain to the district court. AFCO didn't deal with that.
AFCO doesn't even apply here, is your position.
AFCO doesn't even apply here because the statutes are completely different, and the appellate and the appellate procedures and steps in the process in terms of where filing needs to happen are completely different. So that's why, because I agree with Your Honor, AFCO, if it were the same set of facts operating under the same statutes, would apply here. The statute we care about here is KSA 77-613, which is the statute that dictates when and how to file an appeal of administrative decision. And so that's the statute that applies, and that statute specifically leads with the words subject to other requirements of other statutes, which would necessarily include.
That's wonderfully broad language, isn't it?
Well, I mean, it is broad. I'm not going to lie with you, Judge, but I didn't draft it. So
that's right. But you can deal with it. You can cite it.
Right. But because of that opening statement, it necessarily brings in other relevant statutes, which necessarily requires us to look at 60-2001, which says you need to pay the fee. But I want to get back to Supreme Court 119 because that deals specifically with fax filing. And that Supreme Court rule states specifically, if the credit card, for example, is declined, it is not deemed filed under 2001 or 203. And so to your point, to Your Honor's point about the check,
that's right.
Is it filed when the check is sent in? Well, if I'm following the logic of 119, if that check is declined, that document was never filed. So payment is necessary in this particular case, which is distinct from AFCO. It's also distinct from Analec, which is unpublished because Analec deals with paupers petitions, and so it's a different animal.
All right, and that means then that document is not filed, is not filed until payment is made.
Correct, Judge.
So it can be presented to the court one day and the payment is made 30 days later. So when's the filing date? When the money is paid or when it was presented to court?
Well,
And
Judge,
what statute governs that?
well, Judge, I would say that it hasn't been presented to the court at any point. It's been presented to the circuit clerk of the district court, which under 60-2001 requires payment. So this isn't a situation where somebody walked into court and tried to file a paper there. That's not the situation here. Again, that kind of distinguishes counsel's use of 60-205, which is not an applicable statute because that deals with all filings that take place after the initial petition. So filing a motion to dismiss, for example, that's deemed filed when it's filed. But if you're filing it, but in this case, under the rules that apply to appealing an administrative court order to the district court, we submit that the rules are clear. Payment must be made. This is and not to and of course I don't we haven't spoken all that much about the administrative orders that specifically say fax filing is not an approved method without payment. Counsel was aware of that. He stated he was aware of it. He was and so and on top of all of it, in terms of the discretion, I wanted to transition to that quickly so I don't run out of time, and I want to respond to counsel. There is a provision in both Supreme Court Rule 122 that is reflected in the administrative orders that indicate a court can exercise discretion and resolve an issue that was caused because of the breakdown of the electronic system. This court should be aware of the fact that in their own brief, counsel or the appellants admit they were never planning on filing electronically. They were always planning on fax filing. They were not planning on paying immediately when they fax filed it. This is all in their brief. And so, in other words, this entire episode of trying to file this appeal, and I will admit, I probably haven't practiced as long as counsel has or the members of this court. But I know this, if I'm up against the statute of limitations, I'm doing anything I can to get that thing filed on time, to remove any doubt. And in this circumstance, counsel is notified that he needs to send in payment, and he waits an additional 3 days to do that. He was notified on the 3rd of November, doesn't send in a check till the 6th. So in terms of discretion, this case isn't one that should receive any, quite frankly. So just to kind of put a bow on this, the arguments that counsel has presented are largely inapplicable. Federal court law, inapplicable. Although the 10th Circuit, as I noted in my brief, has actually found that the payment is jurisdictional, if we want to take a look at that. But 60-205 is not applicable. It's 60-203. That turns us into 60-2001, which requires payment. AFCO is inapplicable because it deals with a filing in a completely different court, in a completely different circumstance, under a statute that no longer exists. And ultimately, Your Honors, this is a case where the appellants just, I mean, quite frankly, assumed they could file without paying and it was going to be fine. And so that I believe that perspective removes any discretion or any leniency that this court may provide. Although I will argue that counsel didn't seek leniency or leave to file. This issue only came up after we filed our motion to dismiss. So we do believe, Your Honors, that this decision should be upheld and this case closed at this point. So unless there's any other questions, we'll cede our time. Thank you.
Chief, your your microphone.
Any
There we
other
go.
questions from the
No.
panel?
No, I have none.
Okay, Mr. Baker, you have your rebuttal time. I'm sorry. I hate it when people do that, and
Sure.
I'm just going to keep it on.
All right. Let's deal with the first thing. My friend opposing counsel said I never intended to file e-file. I have to file e-file. There's no alternative. That if e-filing is there, you have to e-file. So the idea that I wasn't going to e-file, I had to do that. Let's get to 6205. His theory of 6205 is that a pleading is not a paper. But it says that as otherwise, each of the following papers must be served, and then it says a pleading. A pleading is a paper, and it says a paper is delivered, is filed when it's delivered. His idea that a pleading is not a paper is nonsensical under 6205. The pleading doesn't have to be served, but the pleading is a paper. So that part is there. So it was filed, it was delivered to the court. The court should deem that filing, and look, this was paid. I got noticed on November 3rd. That was the appellate or the filing period had passed. So it didn't matter. I put the check in the mail and it got there. But they did get paid. So it's not like, and the filing date should be reflected as of October 28th, which is timely. So the court should deem that filing timely. We don't even have to invoke the emergency order, but even if you did, the trial court should have considered this, had a discretion to deem it timely. Given
What is your response to counsel's statement that you didn't file a motion you didn't seek leave of the court to file out of time?
Assuming that my filing was untimely,
right?
Which
so say looking at it, you can say, well, they might consider this out of time. Perhaps I should seek leave to do that.
Judge, and so that procedure to say it was filed. I didn't get noticed until later. The clerk did receive the filing and did docket it. So I didn't have any understanding that it was untimely until
the motion to dismiss.
Until they filed. So I'm not going to anticipate that until they raise it.
All right.
That's all I have, Judge.
Any questions from the panel?
None for me.
Okay, thank you very much. We'll take this matter of advisement and get a decision out as quickly as possible. We appreciate your arguments today.
Thank you.
Thank you, Your Honors.
Mhm. Okay. I think we have everybody here for our last case on the docket today. This morning, that is 126789, State of Kansas versus Quinton, Kirk, Lawton. Would the parties state their appearances, please?
Good morning, Your Honors. Emily Brandt of the Appellate Defender Office here on behalf of Quinton Lawton, the appellant, present, ready for argument. I would request 5 minutes of rebuttal time this morning.
Thank you.
Good morning. May it please the court. The state appears by Deputy District Attorney Jody Liffin.
Okay. Again, you're both people that have appeared before us numerous times. You know the drill. So, Ms. Brandt, why don't you go ahead and get started, and y'all have 5 minutes of rebuttal.
All right. May it please the court. There are two issues before this panel today. The first being whether or not notice is required to convict someone of trafficking in contraband under KSA 215914A3, as it is under subsection A1. And the second, whether or not Quinton received that notice. Here, the state has conceded that notice is an element of the crime. So unless the panel has questions about that, I thought that I would focus my time this morning on the second issue. Did Quinton receive fair notice? Quinton says no. He'll concede that after the Kansas Supreme Court's recent opinion in State v. Hinestroza, that he's not entitled to individual notice, but he is still entitled to fair notice in order to be convicted of trafficking in contraband. And here, as you are all well aware, this court is not a fact-finding court, and we have here a fact finder who held that there was no notice. The fact finder specifically says that while he's considering, the fact finder here is the judge, this is a bench trial. Now I have to suspect that there's probably on the wall in the jail, when you're booked in, it says it's illegal to possess drugs inside the jail, but I don't have any evidence of that. I have to imagine that if an individual booked into the jail were given a hard copy of the handbook, there would be a record that they'd have to sign off on it, that they got it. But I don't have any evidence of that either. But the issue is not notice. So I think we have the fact finder here making it very clear that he didn't believe that notice was required to convict Quinton of trafficking in contraband. But if notice had been an issue, he would have acquitted Quinton of the offense because there wasn't any notice. And he says as much at sentencing as well, when he's considering Quinton's motion for a judgment of acquittal. He says, the evidence was that not every inmate in the Shawnee County Jail was given a copy of the policy and procedure manual. It's
Counsel,
just that, yes,
may I interrupt you, please?
of course.
Is it your argument then that the essentially making negative findings here?
I guess that would be correct, Your Honor. The district court judge, who is the fact finder in this instance, is making a finding that there was no notice. But the fact that there was no notice is irrelevant to whether or not Quinton can be convicted, because under his interpretation of the statute, which is based on Pick's comment, that notice wasn't required to convict. So absent notice, he could still convict Quinton of trafficking in contraband.
So I'm going to talk a little bit about what it means to have fair notice. It strikes me that it is, whether you are in the jail or outside of a jail, it is illegal to traffic K2. Would you agree?
Well, I would agree that it's illegal to possess K2, regardless of where you are. I would not agree that it's illegal to traffic K2 into a jail unless you have notice of it, but...
All right, so that gets to my question, and that is, if we're talking about, if it's not individualized notice anymore, if it's just fair notice, then isn't it safe to say that people have fair notice that if you can't possess or traffic something outside of jail, you also can't possess or traffic it inside of jail? It's not like when you go to jail, suddenly, all the rules are off unless they tell you otherwise.
This is true, Your Honor. However, although I don't believe individualized notice is required, which is a standard that Taylor set forth, I think that Taylor is still good law on the issue that the legislature completely gave jail administrators control over what is not contraband within their facilities. The trafficking and contraband statute used to have a laundry list of items that were considered contraband, but in 1997 they amended the statute to get rid of it, and so they have completely delegated authority to jail administrators to define what is contraband. And so it doesn't actually matter if the item possessed in jail is also illegal to possess outside of the jail.
I want to stop you there, though, because Watson involved contraband or possession of 10 cigarettes. And outside jail, it's not illegal to possess 10 cigarettes. Hinestroza involved the possession of a gun, and absent some kind of felony conviction or something along those lines, outside of jail, it's not illegal to possess a firearm. So isn't it different here where we're talking about something where it is illegal to possess or traffic outside of jail? Isn't there something that can be said, as the district court did, and that you don't have to have additional notice? If it's illegal outside of jail, then it's illegal to traffic her inside of jail.
Your Honor, I really don't think so because Taylor very explicitly says, and again, we're talking about marijuana in Taylor. And so we are talking about something in Taylor that is illegal to possess or traffic, et cetera, outside of the jail, and makes it very clear that because total control has been given to jail administrators to define what is contraband, it's not relevant whether or not the item possessed is illegal to have outside of the jail. The administrators of the jail must give people notice about what is contraband inside of it.
Well,
And
just
Taylor
just a second, counsel. Are you arguing then that the administrator of a jail could make it okay to have heroin in there because that's their discretion? Is that your argument? They could make it okay to possess that in jail when they couldn't possess it outside of jail legally?
I think that if the legislature wanted people to not have any drugs in jail, they could have continued to define contraband within jails via statute, and they did it. So it's totally at the discretion of jail administrators, and absent some indication here that that Quinton knew that he couldn't have drugs in the jail because it was specifically defined as contraband within the Shawnee County Jail, there's no notice.
Is there anything that you, counsel, or Mr. Lawton has relied on to think that that you have to have additional notice other than the fact that you couldn't possess it outside of jail, that somehow was he led to believe that he could possess it?
There's nothing in the record that says he was led to believe that he could possess it, but it's also not Mr. Lawton's burden to put on evidence that he was on notice. So there's no rebuttal that I actually was told I could have K2, so you can't convict me of this. The state had the burden of putting on notice that he knew he couldn't, and they didn't. So there's insufficient evidence to convict him of this crime. He doesn't hold any burden here. Additionally, I would like this court to consider the fact that even when we're in sufficiency land, this court doesn't reweigh evidence or make credibility determinations. And really, I feel like the shoe is kind of on the other foot here, because that's essentially what the state is asking you to do, is to credit one jail lieutenant who, not involved in the booking process, doesn't appear to upload handbooks to residents' tablets, doesn't provide residents with physical copies of the handbook, never gave Quinton Lawton his tablet or knew whether or not he had a physical copy of the handbook. I mean, they're essentially asking this court to say, well, the fact that one lieutenant said that the handbook said X, that's enough that Quinton was on notice. But we have a finder of fact here that says Quinton wasn't on notice. And I don't think that this court should be wading into credibility of one jail lieutenant, particularly when we have another jail officer who says, residents didn't get copies of the physical handbook with any consistency. I also didn't book Quinton into the Shawnee County Jail. I have no idea what was on Quinton Lawton's handbook. Nobody entered the handbook into evidence. So we don't know what the handbook said explicitly was and was not contraband. There just simply is not any notice here that Quinton couldn't possess K2 or synthetic marijuana while he was in the Shawnee County Jail, regardless of whether or not it's illegal to possess while outside of the jail. So unless this panel has any other questions, I'll save the remainder of my time for rebuttal.
Any other questions from the panel?
None from me.
No,
All
thank
right.
you.
All right, you may proceed.
Thank you, Your Honor. Good morning again. May it please the court. The state's position here is that we did provide, or there was sufficient evidence here to convict the defendant of the crime in this case. First of all, I'll start out with our position that we disagree with the district court's, with what the appellant says that the district court found about notice. Again, as opposing counsel has read, the court basically found two things. that there's probably signs on the wall in the jail that talk about how it's illegal to possess drugs, but there wasn't any evidence of that here, which we agree there wasn't any. And there was probably some sort of record when a defendant is given an actual hard copy of the handbook, and the judge didn't have that here either. But I'll go ahead and read the next sentence. But to me, the notice is not one of whether the defendant was placed on notice that it was illegal for him to possess illegal drugs. The issue was whether he possessed illegal drugs in the jail, and that was done without the permission of the folks running the jail. So in context, in the totality of the district court statements here, I believe the district court was saying, I didn't have evidence of a sign. I didn't have evidence of when he actually got a physical handbook, but that's it. The evidence isn't whether he's allowed to have drugs in the jail. It's whether drugs are considered contraband or without the permission of the folks running the jail. And that's what he had. So our position is that he didn't make a finding that there was no notice. And as I think we all agree now, post Hinestrosa, we just have to have fair notice. And as Judge Warner, you were saying, I think it's fair to say that it's fair notice that you can't, if marijuana K2 is illegal outside jail, you also can't have it inside the jail. So I think that's
so basically what you're asking us to find is that as a matter of law, notice will be presumed if the item is illegal outside of the jail.
I think this court could hold that. I also could think just in the circumstances, fair notice when something's, yes, illegal outside, that's fair notice that, persons of common knowledge, I had it written down somewhere in my brief, whatever Hinestrosa said exactly, persons of common knowledge would know that.
Well, and we don't allow we know the adage, ignorance of the law is no excuse. So if someone outside of the jail doesn't realize that synthetic marijuana is not illegal, that would not be a defense for them in their criminal charge.
Correct.
Right.
And I think additionally here, if this court wants to go further, I think that in my brief, I outlined the other evidence that the state did put on. I think Lieutenant Biltoff testified that every single inmate was given both a physical copy of the inmate handbook when they were dressed in, as well as a digital copy. Although he didn't specifically give this inmate either, he did say that every inmate was given one. The defendant himself admitted they had a tablet. And Lieutenant Biltoff and at least one other officer testified that the inmate handbook was on the tablet, and that the handbook stated that inmates are not allowed to smoke or introduce contraband or possess dangerous contraband, which includes smoking materials or drugs. So I think the court did have enough here. I think you look at this in the light most favorable to the state, which is something to remember as our standard of review, and that this court can uphold the conviction here and find that there was sufficient evidence presented by the state. And I don't have any further presentation unless there are any other questions from the court.
No further questions? Okay, thank you. Rebuttal, Ms. Brandt?
I'll address just a couple of things. First, I want to address Hinestrosa's use of the term common knowledge. In Hinestrosa, we have a defendant who admitted that they knew that they could not have a weapon inside the jail. And so people of common knowledge would know that a gun is a weapon. So she knew she couldn't have a gun within the jail. The same thing is seen in Garcia, which is the unpublished case we relied upon. He admitted that he knew he couldn't have drugs in the jail, and he had marijuana. We don't have any admission from Quinton here. You can't impute common knowledge of anything to him. We're not making some inference from, well, you said.
Why can't you impute common knowledge to him?
Because I think it's just a different factual scenario than the other cases where we're saying, well, based on common knowledge, you knew you couldn't have a weapon, and common knowledge tells us that the guns are weapons. But
because you had a two-step process that you had to go under there, that a gun is a weapon, and here there's only one step. Drugs are illegal. Drugs are illegal outside the jail. Wouldn't it then be common knowledge that drugs are illegal inside the jail?
Your Honor, I don't think so. Again, because we have in Hinestrosa, we have a defendant admitting that they knew something was contraband. And so common knowledge says that a gun is a weapon. You knew weapons were contraband, so you knew you were bringing something in you couldn't have. Here, again, we don't have any evidence, and besides one lieutenant's testimony about what a handbook that wasn't admitted into evidence says, that residents of the Shawnee County Jail can't have drugs. We don't have Quinton saying, I knew I couldn't have drugs. And people of common knowledge would know that K2 or synthetic marijuana are drugs. So you knew you couldn't have the K2, Quinton. We don't have that here. Quinton never admitted that he knew he couldn't have drugs or admitted that he knew drugs were contraband, etc. And again, I disagree with the state's contention that there was notice in her narrowing of the district court's findings here. Again, I think when the district court says notice is not the issue, it's whether he possessed drugs in jail without permission of jail administrators. But that's not true. Notice is the issue. Of course, if notice is not the issue, then I can say that Quinton possessed marijuana without permission of jail administrators. But because notice is required, he's not finding that he has notice here. And again, I understand the state, letting this court know that when we do sufficiency, we look at the evidence in light most favorable to the state. But I just think it's just different here when we have a fact finder saying, I'm not finding notice. And for us to then go back and reweigh the evidence, because did that lieutenant testify about what the handbook may or may not have said? Yes, but he also testified that residents would be let into the Shawnee County Jail without ever receiving a copy of the handbook. They weren't just going to turn people away. They weren't going to say, oh, we can't book you in, we didn't give you a handbook. They would book people into the Shawnee County Jail without a physical copy of the handbook, without a digital copy of the handbook. Nobody could testify when they started putting the handbook onto tablets. Nobody entered Quinton's tablet into evidence to show that it had a copy of it on there. I mean, we don't have, frankly here, I just don't think there's any evidence of notice. And I don't think it's fair to say that because drugs are illegal outside of the jail, that they're illegal inside of the jail, particularly when the legislature has made the choice to totally abdicate authority to jail administrators to say what is and is not contraband within their facilities. And we don't have we have no testimony from the jail administrator here. We had testimony from the jail administrator in Garcia, specifically about what was and was not allowed within his jail. We don't have any of that here. We have two random jail employees from the Shawnee County Jail who are not involved in book-in, who did not give Quinton a copy of the handbook, who did not enter the handbook into evidence. There's simply no notice. That Quinton was simply on no notice, not fair notice, not individualized notice, not adequate notice, that he could not possess K2 while he was in the Shawnee County Jail. And for those reasons, I think this court has to reverse his conviction. So unless this panel has any other questions, I'll cede the rest of my time.
Any other questions from the panel?
I have none.
Okay, thank you both very much. We appreciate your argument today. We will get an opinion out as soon as possible, and be safe out there.